Ground lease versus land lease. Understanding ground leases and land leases is essential for anyone dealing with commercial real estate. These terms, often used interchangeably, refer to leasing agreements where the tenant rents land from a property owner, usually for long-term use. But what sets them apart? Let's break down the critical differences and legal implications to help you navigate these complex agreements. Legalities of ground and land leases in New York. Ground leases are a valuable tool for property owners and tenants. These agreements allow landowners to lease their property for extended periods, often from 50 to 99 years. The tenant typically constructs buildings on the leased land, but the land remains under the landlord's ownership. Legal nuances in these agreements require careful attention. A New York real estate lawyer can help ensure compliance with zoning laws, tax obligations, and lease provisions. Ground leases often address critical legal points like rent adjustments, maintenance responsibilities, and dispute resolution mechanisms. A well-structured lease agreement reduces the likelihood of future conflicts. Avenue Law Firm's attorneys have extensive experience with New York's dynamic real estate market and can assist clients in negotiating terms that safeguard their interests. Key differences between ground and land leases. While the terms ground lease and land lease are used interchangeably, the primary distinction lies in usage. In both cases, the tenant rents the land but owns the building constructed on it. These leases are more common in New York City than elsewhere, especially in high-value areas. Ground leases often involve commercial properties, such as office buildings or retail spaces. Tenants enjoy the flexibility of building on prime real estate without purchasing the land. Land leases, while similar, can also apply to residential properties, such as co-ops or condos, where monthly fees cover land rent. Both lease types can be subordinated or unsubordinated. Subordinated leases allow the tenant's lenders to take priority over the landlord's claim. This setup is riskier for landlords but can yield higher rents. Unsubordinated leases protect the landlord's interest, as the land cannot be seized if the tenant defaults on loans. However, they may limit the tenant's ability to secure financing. Understanding these differences is crucial when structuring a lease to ensure all parties are clear on their rights and obligations. What is the process of building on leased land? When a tenant enters a ground lease, they generally retain ownership of any buildings they develop during the lease term. This setup benefits tenants who want to avoid the hefty cost of purchasing land. However, the landlord retains the land's ownership and typically regains the building when the lease ends. Developing on leased land involves navigating financing challenges, compliance with zoning regulations, and maintenance obligations. Lenders often view such developments as higher risk since tenants don't own the land, making loan terms stricter. But carefully crafted lease agreements that exceed the loan term can ease financing hurdles. Real estate attorneys at Avenue Law Firm ensure lease agreements are financeable, protecting both the lessee's and lessor's long-term interests. Building on leased land offers significant potential for financial gain, but careful planning and legal advice are essential to avoid costly mistakes. For those considering entering into ground or land lease agreements in New York, Avenue Law Firm can provide comprehensive legal assistance. Our attorneys will guide you through structuring and negotiating favorable terms that protect your assets. Visit us at 505 Park Avenue, Suite 202, New York, New York, 10022, or call 212-729-4090 today to schedule a consultation.